life doesn't always go to plan. Sometimes you make plans for your financial future and they get ruined by unexpected events. Whether this unexpected event is an illness or an external force acting on you, it can at times be impossible to prepare for. If your debt starts to add up and there's no foreseeable way to pay it off in the future, bankruptcy may be an option for you or your business. In this video, we are going to review everything you need to know about bankruptcy, from what the point is to all the different types and everything in between. Bankruptcy is a legal proceeding involving either a person or a business that is in a situation where they cannot repay their debts. The process begins with the petition filed by the person or corporation in debt, or less commonly, on behalf of those who are owed the debt. All of the debtor's assets are measured and evaluated, and these assets are used to repay a portion of the outstanding debt. Your debts will fall into two categories: secured and unsecured. Secured debt include loans in which the creditor has a security interest in the properties that was provided as collateral when you took out the loan. Mortgages and car loans are the most common, the collateral being your home or car. Unsecured debts are not secured by collateral. These include credit card debt, medical bills, and personal unsecured loans. Courts considered secured debt to be of higher priority as the creditor can lay claim to the property serving as collateral. Once all the essential information has been filed with the court appoints a trustee whose job is to make sure that your secured debt is repaid over the given period. Remember, bankruptcy is a complex process and is extremely difficult to go through it alone. If you've decided to go ahead with filing for bankruptcy, working with a bankruptcy lawyer can help ensure the process goes as smoothly as possible and complies with all the applicable rules and regulations. If you can't pay for a traditional lawyer, consider using an affordable legal service to get legal advice while you manage your bankruptcy case for yourself. Every case is different, and you could end up losing property or rights if you don't know what you're doing. Other steps you'll need to follow, depending on your location, will include attending a counseling session and attending some classes that give you information about bankruptcy and how to better manage money in the future. A common question is, what is the point of bankruptcy? Well, bankruptcy actually solves two problems. It gets people or corporations out of debt they cannot possibly repay, and it allows the creditors to get at least a portion of what they are owed immediately. Bankruptcy gives those in debt a fresh start, usually wiping most, if not all of their debt through a court order known as a discharge. There are 6 different types of bankruptcy in the United States: Chapter 7, 9, 11, 12, 13, and 15. The types of bankruptcy are named for their respective chapters in the United States Bankruptcy Code. The main types usually filed are Chapters 7, 11, and 13. Let's start by comparing and contrasting Chapter 7 and 13. Chapter 7 and 13 are the main two types of bankruptcy that affect individuals. Either one can help you when you do not have the means to pay your bills, but there are very important differences between the two. Chapter 7 bankruptcy is known as a liquidation bankruptcy. Your assets will be sold to pay off debts with a few exemptions. Exemptions include some assets, typically including part of the equity in your home, an automobile, personal items, clothing, tools needed for your employment, pensions, social security, and other public benefits are exempt, meaning that you get to keep them. But your remaining non-exempt assets will be sold off by a trustee appointed by the bankruptcy court, and the proceeds will then be distributed to your creditors. Non-exempt assets may include property, other than your primary residence, recreational vehicles, boats, a second car or truck, collectibles or other valuable items, bank accounts, and investment accounts. If you owe money on a secured debt, you'll have the choice of allowing the creditor to repossess the property and discharge the debt, or if you're current on your payments, keeping the property and continuing to make your payments under the contract. Chapter 13 bankruptcy is referred to as a reorganization bankruptcy. In this type of bankruptcy, you are allowed to retain your assets, but you must agree to repay your debts over a specific period of 3 to 5 years. The trustee collects your payments and distributes them to creditors. Chapter 13 bankruptcy is normally chosen by people who want to keep their non-exempt property intact or buy time against foreclosures or property seizures. Whether to file for Chapter 7 or Chapter 13 is not your decision alone. The court also imposes a means test to determine whether you are eligible for Chapter 7. The means test first compares your average income over the previous 6 months with the median income for a household of your size in your state. If you earn less than the median, you should be eligible for Chapter 7. Even if your income is higher than the median though, you may be eligible after subtracting certain allowable expenses. But if the calculation shows that you'd have enough disposable income left over to begin repaying your debts, rather than simply having the slate wiped clean, the court may decide that Chapter 13 is your only option. To help determine your eligibility, you will be required to fill out a 122A-2 form. Take a minute to look over any information you find of value in this chart that compares Chapter 7 and 13. Chapter 7 bankruptcy is typically for people with a limited income who do not have the ability to pay back all or some portions of their debt. If you are deemed to have the means to repay at least some of your debts, you will be required to use Chapter 13 bankruptcy. Chapter 13 is also called a wage earners plan. To qualify, you must have regular income, total unsecured debts under $394,725, and total secured debt under $1,184,200. A question you may have is if you need to repay all of your debts with Chapter 7 and Chapter 13 bankruptcy. Well, certain debts can't be wiped out in Chapter 7 or Chapter 13. This includes mortgages, car, and student loans. If you file for Chapter 13 protection, you may be able to have the balance of certain secured loans reduced. For example, in a Chapter 13 cram-down, your court-approved repayment plan may reduce the balance on your car loan to the depreciated value of the car. That can make the repayment easier. Unsecured debts, such as credit card balances and medical debt, can be discharged in both types of bankruptcy. As stated earlier, this means the debtor is released from the liability of the debt, meaning you no longer have to pay it. In a Chapter 13 bankruptcy, your unsecured debts will only be discharged after you complete the repayment plan. There are some debts, however, that cannot be discharged at all. This includes child support, alimony, student loans, court restitution orders, criminal fines, and taxes. You can't use bankruptcy to completely wash your hands of debt, but it will make a significant difference in the amount of money you end up paying to your creditors. Now you may want to know how long a Chapter 7 or Chapter 13 bankruptcy will stay on your credit report and the impact it'll have on your credit score. If you were already behind on debt payments before you filed for bankruptcy, your credit scores may not fall much more once you apply for bankruptcy protection. But typically, a Chapter 7 remains on your credit reports for up to 10 years, and Chapter 13 remains on your credit report for up to 7 years. For the 7 or 10 years that a bankruptcy is listed on your credit reports, there will be a negative impact on your credit scores. As time goes by, however, the impact of the bankruptcy on your scores will decline. During this period, you can also begin to rebuild your credit by making on-time bill payments and managing your debt smartly. Chapter 11 bankruptcy is most often used by businesses, but can also be used by individuals who do not qualify for Chapter 13, who want to reorganize their debts. They can catch up on mortgage arrearages, restructure debt on investment property, and in most cases, pay pennies on the dollar towards credit card and medical debt. Businesses often file Chapter 11 bankruptcy, the goal of which is to reorganize, remain in business, and once again become profitable. Businesses are not able to make these decisions, however, without the approval of the courts. Filing Chapter 11 bankruptcy allows a company to create plans for profitability, cut costs, and find new ways to increase revenue. Their preferred stockholders, if any, may still receive payments, though common stockholders will not. Chapter 11 bankruptcy is the most complex of all bankruptcy cases. It is also usually the most expensive form of a bankruptcy proceeding. For these reasons, a company or individual must consider Chapter 11 reorganization only after careful analysis and exploration of all other possible alternatives. Some other, less common bankruptcy filings include Chapter 9 bankruptcy, available to financially distressed municipalities, including cities, towns, villages, counties, and school districts. Under Chapter 9, municipalities do not have to liquidate assets to repay their debts, but are instead allowed to develop a plan for repaying them over time. Chapter 12 bankruptcy, which provides relief to family farms and fisheries. They are allowed to maintain their businesses while working out a plan to repay their debts. and Chapter 15 bankruptcy was added to the law in 2005 to deal with cross-border cases, which involves debtors, assets, creditors, and other parties that may be in more than one country. This type of petition is usually filed in the debtor's home country. It is important to know how to rebuild your credit after bankruptcy. As just mentioned, bankruptcy will remain on your credit report for either 7 or 10 years. That can make it difficult to obtain further credit, such as a bank loan or conventional credit card. However, the effect of bankruptcy on your credit score will diminish over time, and your score will gradually improve if you show you're using credit responsibly. One tool for doing that is a secured credit card, where you make a deposit with the issuing bank, which then becomes your credit line. By using that card judiciously and making your payments on time, you can begin to establish a free credit history. After a period of on-time payments, you may be eligible for a regular, non-secured credit card. The process of rebuilding your credit and restoring your financial life can take time, but bankruptcy, if you have no other viable choice, is not the end of the world. Before filing for bankruptcy, there are a number of steps you may want to follow. For example, find out if your creditors are willing to negotiate. Rather than wait for a bankruptcy settlement and risk getting nothing at all, some creditors will agree to accept a reduced payment over a longer period of time. In the case of a home mortgage, call your loan servicer to see what options may be available to you. Some lenders offer forbearance, postponing payments for a period of time, repayment plans, such as smaller payments stretch over a longer period, or loan modification programs, which might, for example, lower your interest rate for the remainder of the loan. Even the International Revenue Service is often willing to negotiate. If you owe taxes, you may be eligible for an offer in compromise, in which the IRS will agree to accept a lower amount. The IRS also offers payment plans, allowing eligible taxpayers to pay what they owe over time. There are of course many things we did not have the time to cover in this video, but now you should have a good understanding on the different types of bankruptcy. As always, thank you for watching and leave any tips you may have in the comment section below.